Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And welcome back to the show, my good friend, Mr. Joe Neerman. How you doing, buddy?
I am doing really well, thank you. How have you been?
I have been terrific.
You know, this is our 3-year anniversary.
Oh, really?
This is
like this day?
Practically. I met you the first time it's the 3-year anniversary of my debut on your show. I appeared on your show like 2 days before January 6th. So it's like maybe 3 days. If you go back because we were speculating about what would happen on January 6th. So
yeah.
And
actually,
that was the first time I ever appeared on your show, was like January 3rd or 4th, 2001. So there you go. You didn't even realize that. Like the romance is so strong. It's just he's naturally attuned toward it, inviting me back for the anniversary.
It's funny you say that, because there is a thing for me that I've noticed is that once someone is like, this sounds so gay, and I'm sorry at what's about to happen to you with the rest of the world. But no, once someone is in my life, like as a good friend, or like I think of like my children too, my wife, once they're there, I can't like remember the before time. Like it just seems so natural to this person is just there, like whatever capacity that is. Now, obviously some people like go away from your life, but for me it's like I can't picture life before Joe. I have no idea. You've been there the entire time.
Hey,
we've been best friends for 43 years. That's our secret. We've always been friends.
No, I mean, look, I everyone knows I'm a big fan of you, of you as well. So let's just now exchange our anniversary gifts and just move on.
All right. Well, here, let me stand up and pull my. We're gonna Gavin McGinnis to stream right now.
Anyway, you called this right before the show, right before we started. He called the 14th Amendment, this topic, the most interesting legal thing that's happened since he started streaming, which I agree with you. It's very interesting.
Let me correct you. Since I started doing law at all, including law school.
Wow.
So we go back here on this one to 2011, maybe. When did I start? 2011, I think, is when I started.
Why do you think what makes it so appealing from a legal perspective to you?
150 years. 150 years plus now. The 14th Amendment, Section 3, has existed. The question of if it applies to a president has never been asked. It's never been asked. And everybody assumes that it does. And then when you read it and just think for a second, you go, you know what? I don't actually know. It kind of doesn't look that way. It doesn't seem to apply at all. But then you're looking around and everybody says, well, yeah, of course it does. Like, well, why of course?
Right.
Why of course? And then you start thinking through the ramifications of it applying to a president and all of the things that go into that. And you go, there's a whole lot of reasons that it, of course, wouldn't apply to a president. He's not written down when they could definitely write him in there. They wrote other people in there. They wrote unimportant people like electors in there.
Yeah.
Why is this a foregone conclusion? And then when you realize the ramifications, and this is what I really want to talk to you about, the ramifications of how this particular application is playing out. What happens if a state can disqualify a president out of hand? Mm-hmm. And you get to two big questions. If Colorado and Maine disqualified Trump from being the president under the 14th Amendment, Section 3, and then he gets elected anyway.
Not my president.
What happens? Right. They can't undo their disqualification by vote. So now are they in rebellion against the United States? Because they can't recognize the chief executive, right? And so then you have the other question. If they can exclude a president from the ballot, logically, that means that logically any state midterm can decide a president isn't the president, because the wording of the 14th Amendment does not say cannot attain office. And this is actually a point in their brief. In a different way, it's a point in their brief. It says he cannot hold office, which means if he is holding office and engages in insurrection according to a state court or a state secretary of state, then he can no longer hold that office. But the president hasn't been impeached. So what does that mean in practical terms? If Biden insurrected the United States tomorrow, what does that mean for Joe Biden? Because Texas is now saying he's not fit to be president under the Constitution. So if we allow this in the voting section, we have to logically allow it midterm, right? Like it has to be the same because the wording says hold, not take or attain.
That's true.
Why is this in the cert petition? Why is it that point? Because I thought of this on the fly. I'm like, wait a minute. Why didn't we add this whole logical argument about this in the petition for cert?
That is, or I guess the petition, yeah. That's a really, really interesting argument, whether all of a sudden a state can just say, you're not my president anymore, because I think that what you're doing is engaging in insurrection. For example, and Texas, actually can find a basis for that in that and that the government itself is fighting Texas about putting up the state of Texas about putting up barbed wire along the border. There's a court battle that's going on now with Texas versus the United States, where the U.S. government said immigration is our field. You have no legal right to protect the state of Texas from people invading, and you putting up, and they started cutting down barbed wire, and the state of Texas took the U.S. government to court saying you can't stop us from having people come into our country, into our state over here. And that's actually, to me, that's a really interesting question. When I was breaking down your question that you're asking as to whether an individual state can do this and whether it applies to the president, so I went back and there's different ways you can sort of analyze this 150-year-old amendment. One is you could look at the text. Right, you can look at it as a textualist. You can look at it and say, what do these words actually mean? And then there's a debate that the left is putting forward. We know they're only putting this argument forward today so vehemently. That's definitely true because they know that the actor that it would be applying to is Trump. But as far as whether they actually genuinely would believe it, if you were talking about in a theoretical, philosophical type of way, that's what the text implies, we all know that they would be a lot more ambivalent and perhaps even lean the exact opposite way. It's much easier to say, no, this is what I really believe in my heart, when your heart is motivated by a bias against the person who you're looking to have it attached to. But putting that aside for a moment, so you can have the textualist perspective, you can have the originalist perspective, which is what is happening in the country then? What is the philosophy that's happening then?
Nothing at the time of the 14th Amendment. What are you talking about?
Well, I'm saying is the context, the context of this being during the Reconstruction era, and what was their agenda and objective then. And then here's the other thing, which really, to me, until I saw the briefing from, which I thought was phenomenal briefing by, I think it was Jay Sekulow who wrote the brief when they're petitioning for cert, which I really had a question, which was like, okay, why would it apply to everyone but the president? And they gave a great answer there, which I hadn't really contemplated. I don't know if you went through the brief. Did you go through Sekulow's petition for cert?
Yeah, the one, like they just filed, the one that Trump's team filed, right?
No, well, that was filed by the GOP.
Oh, the Colorado GOP. No, I haven't gone through that one.
Yeah, so I don't know. I didn't get a chance to go through Trump's yet. Have you gone through Trump's?
Yeah, that's the one I went through yesterday. Trump's.
Uh-huh.
And it's pretty
they
good.
address that question as to, like, philosophically, why would it apply to a senator and member of the House and all these other folks, but not apply to the president? Do they bring that up in their petition?
No, not from a philosophical perspective. It's just from the technical writing perspective that
right.
they didn't include president. They include everybody else in descending order of office, starting with House and Senate, and then going down from there to electors, and then to officers. They quibbled over the lack of the word "other officers" of the United States, which would imply that the president may be included if it was other officers. Although there's a law review article that came out today. I haven't read all of it because it's 78 pages, and they're arguing that officers of the United States does include president. Contemporaneous with both 1792 and 1868. It wasn't convincing to me, but I'm biased because the plain wording of the text belies the idea that it does. But anyway, and they also, they focus on the oath to support the Constitution, and the presidential oath, which is a constitutional provision, does not actually say that. And the other oaths, which is a different constitutional provision, does say support specifically. So if they got all this here, why are they specifically referencing and alluding to specific language of other sections of the Constitution, but they mean something that they don't write?
Well, on the oath thing, I actually don't think that's one of Trump's particularly strongest arguments. I think that's a fairly weak argument. I'll explain to you why momentarily.
Curious about this.
But I mean, I think that he has 7 really strong arguments, and if I was ranking the strength of an argument, I think the language of the oath is like number 20 on the list, as to because I think that the left can assail that argument fairly easily. But
I disagree vehemently, but I want to.
Well, we'll have this debate. Okay, we'll have this debate where I'm going to end up sounding like a lefty in a moment, I guess, when we have that debate. Thank you so much for positioning me that way.
No. I don't think you sound. I don't think it's a lefty position, or I don't think it's.
I'm trying to engage in intellectual integrity as far as to me, this, what would I lean toward? How would I lean toward understanding? But let's get to that in a moment.
Yeah.
First, I want to just sort of enrich your perspective and think to yourself philosophically. I mean, if we just put aside what language is here, we're not sure if someone were to deem this language ambiguous as far as officer, is it applying to him? And and there's 3 different ways that you sort of have to look at, is it applying it to? Is when they're talking about officer, you're talking about, are they an officer at the time that they're making the oath? Right, sure. Like what office are they holding at the time they're making the oath? What office that they ultimately end up breaching, and then what offices are they barred from holding if they are categorized now as an oath breaker? So, so those are different stages which are sort of massaged through in the Section 3 of the 14th Amendment. But you sort of have to ask yourself, okay, why would we carve out a president? Why would they do that? Why would that make any sense? And you can sort of understand.
I got tons of reasons why.
Why would it not apply to holding the office? I can understand why. An argument you would say why would not apply to the president. Let's break it down to those 2 distinct things. Whether you can fall into the category of someone who this applies to because you were holding an office as president. So the easy argument, which I assume you would make, is there's no such thing as a person breaking their oath to the Constitution when they are president, because whatever they do is naturally going to be considered, almost like a god walking amongst mortals, and that he is the Constitution, he is the embodiment of the Constitution. So you can't be a traitor to your own country if you're the leader of the country. So that would be an argument to say that no president can take any actions which could possibly be classified as something that is breaking their oath to the Constitution.
Let me asterisk that though and say I agree with you in principle, but I'll add the caveat that a president can, in some conceivable way, insurrect or rebel against his own country and own administration. However, when he sufficiently does that, he would be impeached and removed through the process that does it. And upon impeachment, it would retroactively apply that he was not effectively president at the time his actions were committed. Therefore, since he has shed his office by rebelling or insurrecting against the United States, he's no longer president. Now, logically, and
what if he does it on January 20th? So are you able to have impeachment post his term? And if he does it on January, see, here's the thing. You have to sort of approach it and try to understand how would the Constitution actually work and function. So let's imagine that someone did exactly what the left in their heart of hearts believes Trump will do, which is that on January 20th, he's going to assemble the National Guard and shoot up Congress and say, I'm the king of this place forever. And that's what they all genuinely, or at least many of them, not all of them, but certainly the craziest of the left genuinely believe that that's what he would do or will do if he's elected to a second term. So let's say that someone actually did do something like that. Are you saying that would not be an insurrection?
No, I'm saying it would be an insurrection.
But because he's not impeached, they don't have time to impeach him. And you're going to say you can't impeach him after his term is over. So if they go ahead and impeach him on January 21st, you'd be like, well, too late. The impeachment doesn't work. So that doesn't make sense.
Why can't you impeach someone after their term is over?
Oh, so you think a person can be impeached after their term is over?
Sure.
Were you taking that position in 2021?
Well, I think I took the position of we don't know what the Supreme Court would say. about it. The Democrats made sure to impeach Trump before his term was over because they were afraid of how that would work out, I think. But I also think that there's a big question of when the impeachment does happen and then they leave office, or if they leave office and then they're impeached, how that proceeding is supposed to go. Because the way I read it, if you and I look to parallels.
You're breaking up. You froze. Am I the only one who sees him frozen? Am I frozen? Is it me? Can you guys hear me? Maybe we're all frozen. I'm alive. I'm alive. Am I? I must be his camera then. All right. Y'all see me. Woohoo! There are a lot of interesting philosophical questions on this topic. So I'll tell you this. Oh, wow. Look at that. Nice. That's awesome. All right. Yeah, no. So I think a lot of people were making the argument that you cannot be impeached after your term is over. And if you say that a person could be impeached afterwards, by that logic, in theory, Barack Obama could be impeached today for something that he did in 2014, which, is something that seems you sort of figure there's got to be some sort of statute of limitations on when someone can be impeached, you would think. But you're sort of left with this conundrum where we're sort of left thinking, okay, so what if someone actually did on January? If you're going to tell me that you have to be that a president, if he's impeached and convicted, well, what happens if he actually does it when there is no time? Because the left would point out that, look, January 6th left practically no time between then and January 20th. It did leave a very, very short window, which they were cramming to try and get him in on. And they still didn't get the Senate hearings done before January 20th, 2021. And now we're sitting here trying to figure out, is someone who, let's say it actually happened on January 20th. What would happen at that point? Will you tell me that that's not an insurrection? I think everyone would agree that that would be an insurrection. I mean, logically, you sort of have to imagine, forget it wasn't Trump. It was some crazy lefty who was in power and then started shooting up Congress. You sort of have to sort of look at the situation from the opposite perspective. Like, how would you feel if you were sitting there opposed to vehemently opposed to the person who's doing the offense, and then say, okay, how would I feel in that situation, that this is a just way of proceeding? And then you have to sort of figure out, well, let's assume that the Constitution intended to cover that situation. And if the Constitution was intending to cover that situation, there must be some sort of way of reading the Constitution that's consistent with the way that you think that this should apply. And this is why it's such a difficult thing for us to try to wrap our minds around, as far as like what is right, what is wrong. I am so unaccustomed to seeing my face quite this big. I'm feeling like I need to. This is just too big. It's too big. That's better. That's better. Whew. I'm like counting my own nose hairs here. All right. Well, anyhow, I'm not frozen, am I? No, I'm still good. Anyhow, but and the thing that to me that I was really struggling with, and I'll probably end up repeating this again when Nick gets back so you can hear it, because as far as the philosophical logic, remember, there's really two stages here. Some would say three, but there's two stages here, certainly, as far as, does this apply to the president? So the first stage is someone swears to uphold the whole to the Constitution. Put aside what the oath is for a moment. Let's pretend that the president made the same oath as everyone else, okay? And let's forget about that argument for a second. And let's assume the oath issue is not an issue. So someone now is holding a position. Is that a position that when you're in that position, you can fall into this class of people who are now excluded? So if you're holding an oath, let's imagine I'm holding an oath as a lawyer, okay? So now would I be deemed someone who's breaking my oath, and thereby, if I engage in insurrection, that this section of the 14th Amendment would apply to me? So the question is, well, what position am I holding? Am I an officer? Am I a senator? I mean, what if I'm a senator? Yeah. As a lawyer, certainly not. So if a lawyer who joined in the Civil War and then fought there, it would not apply to them at that point. How can you hear you?
Yeah. Sorry, my internet just went out.
No, that's all right.
That's cool. It's back now.
That's all right. I was explaining to them the different stages of the of office holding, and how someone, in order to the section 3 of the 14th Amendment to apply to them, so you have to be holding a certain office, make an oath, and what type of office that is. If the office is that you're an attorney, that's not an office that, if you go and engage in insurrection, it wouldn't apply to you because you're not holding a sufficient office. So
unless you're a district attorney.
Right. Well, if you're a U.S. district attorney, right. So in that case, that's a very different thing, because now you're an office holder. But then the question is, okay, once you fall into that class, what offices that it applies to you, what offices are you now barred from being able to step into? So the question that one would ask is, okay, let's assume that it does apply to you. So now you cannot become a senator. You cannot become a member of the House. You cannot become an elector or an officer of the United States, whatever that means. You want to try and say this. You want to try and say, but you could become president. So you sort of have to understand, if that's how you're reading the text, let's assume that the people who were writing this were not idiots, and they sort of had some sort of basis. There had to be something going through their minds to make them say, oh, yeah, but we're not going to let them hold any of those other offices, but president will allow them to hold. Well, why would they do that? You sort of have to ask yourself that question. Why would they possibly think that that makes sense? And what I liked about the briefing from the Colorado GOP is they came up with a good explanation, which is that, yeah, we don't want you sending a senator here from your state because your state decides we don't care about the fact that you were a general in the Civil War. So we don't want to give the state the power to send someone there. But let's say some general from the Civil War, from the rebel side, decided that they want to run for president, and enough people from the North voted for him that he became president. So now there's a national, there's a national recognition that he's the right guy for the job. Well, in that case, the 14th Amendment, Section 3 of the 14th Amendment should not apply to him. And that is a very logical reason to say that when someone is running for in an election for a national office and has to attain favor in the eyes of the entire country in order to assume that office, that if he can attain that level of favor, in that case, well, Section 3 of the 14th Amendment shouldn't apply to that individual. And that would be a reason to say that you're not barred from holding the office of presidency. That was a phenomenal argument that the Colorado GOP put in there, as far as philosophically why they would bar you from becoming a senator or member of the House, but not be barring you from being able to become president of the United States.
Right. I had a similar sort of conclusion. I worded it very differently, but the idea is simple, in my opinion. It's the political will of at least half the country. And so if the political will is manifest in one person by at least half the country, then the country cannot believe that that person is somehow treasonous or insurrectionist or rebellious, right? Like that is that. And the only cure for that would be removal by Congress, unless they were to just go ahead and listen to Section 5 of the 14th Amendment and make a law about how you would disqualify a president, because it just says in there that they could do that effectively. They may still run into a separation of powers issue, depending on how much authority they tried to give out. But according to the amendment, Congress gets to enforce all of the provisions of the 14th Amendment through Section 5 by appropriate legislation. So
I'll steel man for the left on that, where they say that, look, there's a lot of statutes that are referenced in the 14th Amendment. There's a lot of anti-discrimination elements to it, which states employ all the time and they write laws about. So why would their ability to write laws with respect to the 14th Amendment be limited to other sections of the 14th Amendment, but not to Section 3? So that, and they would interpret Section 5 as saying that this now grants authority for Congress, and recognize that in the age when this was written, this is in the mid to late 19th century,
right,
there was a strong belief in federalism at that point. and Congress's powers to write laws was very limited, in that they were only able to write laws that related to, interstate commerce and things of that nature, but things that happen intrastate, they didn't have that authority. So in general, what's happening in a private election in another state, it would seem like that's something that's beyond Congress's powers to write any laws about. So the purpose of Section 5 in enabling Congress to do so would say, even though you normally couldn't write a statute about this, about laws affecting some senator or member of the House from another state, on this, we're given that Congress will retain that power. And that's the reason why someone from the left would argue that it enables Congress to do that, but that's not restricting that power exclusively to Congress, and states still would retain their federalistic abilities to come up with their own laws. That's how they would try to read Section 5, and they would say, and the indication that that's a more accurate reading is the fact that we can see states applying laws from the 14th Amendment on a state level, and they're not restricted from doing. No one has ever come along and say, no, only Congress can do that. The way they're doing, the way that the right is now saying with respect to Section 3 of the 14th Amendment. So, right. What would you say back to that argument?
I would say, again, Congress has to, according to the 14th Amendment, Congress has to make a law to enforce any provision of the 14th Amendment. Congress may enforce it, which is the wiggle room that the Supreme Court has used to allow some elements of the 14th Amendment to be self-executing, as Pisco would say, although I don't think they're as self-executing as he presumes that they are. There is some level of that, but only when it's open and notorious that they should be. As far as the presidency and what gets to be disqualification, Congress could, in theory, write some process by which states could determine a president to be ineligible. I just can't think of the logical way that they could do that, because we come into the ultimate problem. If one state says a president is ineligible and the other state doesn't, how can that reconcile between the two? That's why it's just so far out of the purview, and why the impeachment clause is a more appropriate way to deal with a president who has insurrected or rebelled, right? Like that.
Well, here's the problem with I think there's a stronger argument against the left on this, because if you're going to try and read that states have the ability to write laws about Section 3 of the 14th Amendment, think this through. It's now 1870. The Civil War is still a fond memory in the hearts of a lot of Southerners, or bittersweet memory because the outcome, but they still have, many of them still have very strong Southern state flavor type of leanings and resentment toward the North. So,
as they should.
So now what you're saying is that when Congress is writing this statute, so the left wants to interpret this as, oh, Congress has the power to write laws and states have the power to write laws. What you're basically saying is that a very racist state in 1868, 1869, 1870 would be able to write their own laws as to how they're going to interpret Section 3 of the 14th Amendment. Can you even imagine that after winning a war to say that no, federal power trumps state power, and hundreds of thousands of people being butchered or butchering their own cousins. Now we finally win, and we're going to enable the state of Virginia, the state of South Carolina, North Carolina. We're going to enable them to decide whether or not their senator, this individual, is engaged in insurrection and can come in here and sit as a senator. That sounds so stupidly ludicrous that you to think that Congress would say, yeah, we're going to allow those southern states to just give their own interpretation of this amendment. That sounds bizarre. Why would they possibly? That's the last thing they wanted. They fought a war to stop that from happening, and now you're going to say, of course, that's what Congress wanted, for states to decide. That makes zero sense at all, and that's why. That's why I think it's asinine for the state of Colorado, the state of Maine, to try reading this statute as giving some sort of power to a state to decide this when clearly the purpose of this amendment was to say, hey, we're not allowing states to decide who's going to be a senator. In fact, that's the reason you have this in the first place. The reason you have this say certain people, we do not want these people here because they're insurrectionists. So now you're going to let the state that just engaged in insurrection decide what's an insurrectionist? That makes zero sense. So that's why I think that reading, to me, and Justice Samara is the one who really pointed this out in his dissent on the Colorado decision, that he was like, it makes no sense to read this. And now with respect to whether it's self-executing and whether it applies to states or not, on whether it applies automatically, and that whole reading, which is, which sort of plays into this as well, you sort of have to sit there and figure out, okay, well, in certain ways, do you think, I'll ask you, Nicholas, do you think that when the 14th Amendment was drafted, everyone was legally freed? Every slave was legally freed by the enactment, by the ratification of the 14th Amendment?
I mean, 13th.
13th Amendment. But 13, 14, 15 were all the same. Yeah.
Well, they're supposed to be, but they weren't, right? Like, because we know that didn't actually happen. That's what Juneteenth is, right? When the last slaves were actually freed, when they got the memo. But
from a legal perspective, it was self-executing.
The 13th Amendment. I think. I would say yes. But I think there were fights over it, like what happened. Because I know the South tried to file Fifth Amendment. Like, people in the South tried to file Fifth Amendment takings claims, right?
Mm-hmm.
Like, well, you're taking our property. We need to be compensated for this property. And they're like, nah, you don't get that. That's not how that works. Even though, I'm sorry, it maybe should have in concept, if they were actually property and then they decided you can't have it under the takings clause, it probably should have. That's going to get clipped. Well, Joe, it was a nice career. It was nice to know you, Joe. I just said black people should have been treated like... No. But I mean,
I got Fisco to say the same thing in an argument with me.
There were lawsuits about it. Like, that was the thing. They're like, hey, this is a taking. We invested in this. We bought this property, and now you're taking it away by law. So our use is gone.
When I was arguing with Pisco about this, so I was like, don't tell me that. I said, because I said that there should be a reading of these amendments designed to broaden civil liberties. So, and that, to the extent it's broadening civil liberties, it's self-executing. If it's not broadening civil liberties, if it's restricting liberties, then it cannot be self-executing. You cannot just take those away from people. Congress can give rights to people, can recognize rights of people, but they cannot just take things away from people. That would be a violation of due process. So that's why I said that. So since it's granting, that abolition is granting civil freedom to hundreds of thousands of slaves, so that would be something which is self-executing. But if you're going to be taking away someone's right to run for office, that cannot possibly be self-executing, because you're now depriving someone of rights without due process. So that's why I said it really depends on what parts of these of those amendments you're referring to. So he responded, well, when you gave them when you gave them their freedom, you were taking away from the Southerners who owned them. So how can you just take that away from them that would be, it was helping black people. You were taking them away from white people without due process. So I said, so I responded, are you considering that the same level of civil liberty, that the right to your own personal freedom is the same thing, and that you're feeling bad now for the slaveholders? You're arguing that the slaveholders were now who lost the war, were now wrongly deprived of their property. That's what you're claiming. That's what you're rooting your whole claim here. That's not fair. You think that's not just? You think that's improper? And
yeah, I don't think that at all. I do think that I do think freeing the slaves under the 13th Amendment, the abolition of slavery and involuntary servitude, is self-executing. I think that is actually evident. I don't think Congress had to make a law that follow up that says, oh, by the way, you can't have slaves. Someone in the chat pointed out that the second section of the 13th Amendment does say that Congress shall have the power to enforce this article by appropriate legislation. It does say that, but that's not the only thing that the 13th Amendment says. It also says that there's a crime whereof the party shall have been duly convicted shall exist within the that is a way that you can provide involuntary servitude effectively as a punishment. So there are parts of the law that Congress or parts of the Constitution that Congress can still define the rules around following the abolition of slavery and involuntary servitude. But it clearly says that it shall not exist within the United States or any place subject to their jurisdiction. So that part of it, I would say, is definitely self-executing. Now, again, did everybody follow self-executing laws? Don't mean anything. There's a bunch of laws that say you can't murder people, and people still do. So like, laws are words on paper, and they have legal effect. When Southern slave owners sued the United States under the Fifth Amendment, they lost. There was not a takings there. They said, nope, this is actually this is repugnant to the Constitution. We do not treat these people as property anymore. You lose, you don't get compensated for it, blah, 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 blah. So, but there are still parts of the 13th Amendment that had to be carved out through legislation. I would say the same with the 14th Amendment. I mean, the Civil Rights Act is effectively done under the 14th Amendment and the Equal Protection Clause of the 14th Amendment, right? Like, the whole idea is that Congress can enforce the preservation of rights on private entities through the 14th Amendment and the equal protection of laws. They did that by appropriate legislation, the Civil Rights Act, Title VII. So we have evidence that happens, but
there
it
were
doesn't
also
mean
enforcement laws that were written after the 14th Amendment.
Right.
They were later nullified, but Congress did step up and act. It's not like they didn't do anything. They just ended up repealing them later on. I wanted to ask you about this enforcement because I was just looking at Section 2 after you mentioned Section 2 of the 13th Amendment and contrasting it with Section 5 of the 14th Amendment. And there's a key word which really makes for a distinction over here, which is really interesting. So, and the key word is the. Yeah. If you look at 13th Amendment Section 2, it says Congress shall have power to enforce this article by appropriate legislation. Meaning we're broadening Congress's powers, that they you might not think they have power. They do have power. They have power to enforce this legislation.
Oh, okay. I see. Now I see what you're saying.
But in the Section 5 of the 14th Amendment, it says that Congress shall have the power to enforce by appropriate legislation the provisions of this article. The word "the" there implies they have exclusive power. Who has power? Well, the power belongs to Congress. The word "the" there really changes the nature of the. It really serves almost as a modifier to the word power, saying rather than being a party who has power, but you are the one who has power, and arguably, I think, helps support Trump's position that only Congress has this power because they have the power as opposed to just power, which according to Pisco's reading, it should just say power.
And I can go ahead and support this with other evidence from the Constitution because I love the word "the." In the first line of Article 1, Section 1, the legislative power shall be vested in a House of Representatives, in a Congress consisting of a House of Representatives and a Senate. I'm messing this up. The legislative power, as defined in this article, shall be vested. And then in Article 2, Section 1, the first line is the executive power, which is different than saying the as defined. Now, there isn't a difference between the "thes" there, but both of them are defining specific powers. The legislative power in the first one, but as defined in this article. And the executive power is just left blank.
But
and
they're both being exclusive to who's being described.
Right. The difference between them being one is defined only by what's there, and the other one is as understood in 1792, which is why I often say that the president is a king that lasts for 4 years at a time, because he is. Which is why I would say he's not an officer under the United States, because he is the king over the United States, or the chief executive over the United States. He is above it, quite literally. And if you look at what the executive power was in 1791, you have to look to King Henry or King George, right?
Yeah.
He is the understandable executive, the most powerful one in the entire world at the time.
I think that's beyond dispute. I'll tell you this much. I can support the argument that officer of the United States is different than officer. I agree. I definitely think there's logic behind that, especially if you read through the Constitution. I think that there is a distinction, and by analogy, I've said this on my stream. There's difference when we say that you or I as attorneys are officers of the court, as opposed to the judge, who's referred to as the court. He's not called an officer of the court. It's called the court itself. So, and the language of and Article 2 of the Constitution, which is giving him, the president, the ability to appoint all officers of the United States. He's obviously not self-appointing. So if he's the only one who's appointing all these officers of the United States, that almost changes the phrase "officers of the United States" into a defined term. What is a defined term? What does officer of the United States mean? It means someone appointed by the president. That is an officer of the United States. So it cannot be referring to him, and hence, that when the 14th Amendment refers to an officer of the United States, it must be someone subordinate to the president and not inclusive of the president. And I think there's logic behind that. But I mentioned earlier that I don't like the oath argument. And you disagree with me. You said you're going to disagree with me vehemently on that. So it's probably time for us to go to toe-to-toe on that issue.
I want to address one thing in the chat. Richard W. Does not agree with me that the president is the king. If you don't like the label king, that's fine. He is something distinctly different than a king, obviously, because he does not wield the legislative and judicial power in his office. But that's only because we decided to break the power of the king into three distinct branches. The lawmaking power of the legislature was the king's authority as the executive. The judicial power was actually under the king's authority. It was the king's court. It was under the executive. But when they wrote the Constitution, they created the legislative power and defined it in Article 1 and all of the sections. It also happens to be the longest section of the Constitution by a long shot, because they had to create something and clearly define it as something that was not understood. The executive power of the president is not laid out in clear terms. And there's a reason. They understood it. He is the sole organ of foreign relations. He is the guy who is the commander-in-chief of the army. He is the executive decider and the enforcer of laws. It's just the king himself would have made laws. I say king in a tongue-in-cheek and shocking way. You can call him a chief executive because he's less than a king, but realistically, the only reason presidents don't flex the power of a king is because it's problematic when they do, not because they can't. And when they do, they often surprise people by how fucking good they are at being king. Barack Obama handed out 2 million green cards with no qualification, and he won.
Right.
Donald Trump shut down immigration from 9 Muslim countries. And though he had an injunction against him, when it went to the Supreme Court, he won. Andrew Jackson went against the Supreme Court's orders and he won. Ronald Reagan went against just about everything, including Congress, when he fired the entire FAA, and he won. The chief executive is powerful. And the reason that they're not always powerful is because it's scary when they flex. FDR flexed all over the country and he won all the time. And you know how he won? He threatened the judiciary, said, I will just appoint more of you and you will go away.
Yeah.
And he could. Because what's going to stop him?
Yeah.
Because he has the political will. And that's why I think it's really important that the president is not included in the 14th Amendment, because he has the political will of the country. Can you imagine if FDR went against Congress at the height of World War II? Who would have won that fight in political authority? FDR, hands down, would have won. Yeah. The justices knew what would happen if he had to fight them, and they backed off. And that was before World War II. This is his reparation of the New Deal, or through the New Deal of the that was in Depression.
What was that case? You always mention it. It's the
Wickard versus Filburn.
Wickard versus And
yeah. He defeated the other two branches by sheer political power. That's why the president shouldn't be there. Impeachment exists to fix that problem.
And arguably, the reason his powers are not enumerated is you can make sort of two different philosophical reasons. One is because they figured we can't really figure out what he's going to have to do. We don't know what a president may have to do in 100 years from now. And they're writing a constitution that's supposed to be lasting for, hopefully several millennia, if not more than that. So they have enough humility to recognize that they can't they can't foresee every circumstance that a president is going to have to be called into action to make decisions. So that's why, and enumerating his powers would be limiting them. As soon as you start listing off what he can do, that all of a sudden now may hamstring him in a situation that he has to go beyond what's specifically enumerated. So there seems to be by the founding fathers a hesitancy of doing anything that may restrict him, which supports Nick's position that they view him as a 4-year king, a 4-year.
Let me add one more point to it.
Okay.
They were so scared of FDR that when they passed the amendment to limit a president to 2 terms, they said, after this guy is done. They didn't say after his next term. They said after he's done. Right. FDR was so popular. They're like, we cannot have presidents getting elected to 4 freaking terms in a row, but we're not going against FDR. He's got to stay as long as the people want him. That's how popular he was, that the constitutional amendment around presidential term limits was written specifically carving this guy out. Like, presidents are really powerful, and only when they don't want to be are they not. So on to, though, the argument for supporting the Constitution. Here's why I think it matters.
Oh, the oath? Yeah. Okay.
Right. Because the oath that they reference is written in the Constitution. It's in Article 6. And it specifically says support the Constitution. The oath of the president is written in Article 2, and it does not. Why, Joe, would they have literally the words from one oath when they could have said any other argument? Like, they could have said anything else. They could have said an oath to support, defend, uphold, or like they could have listed a couple words that would have encompassed the presidential oath, but they didn't.
Precisely for the same reason that they didn't enumerate the presidential powers.
Right. So why do you think that's a weak?
No, argument? I'm answering your question. It's precisely the same logic that we just expressed with respect to them not enumerating his powers. They used the broadest possible language that they could and said an office, any oath that someone makes to support the Constitution. Now, this applies to anyone who's a justice of the peace who makes an office. There might be 1,000 different oaths that are issued across the country. Whatever oath you're making to support the Constitution, what language could they have used that would express the sentiment of an oath that's meant to upkeep the Constitution if they wanted it as broadly as possible?
I disagree.
What other language could this amendment have put in here, which would be not limiting? And to me, this is the least limiting one that they can come up with, which is an oath to support the Constitution.
But Joe, I just want to point out
and that way they maintain it on a broad scale and apply even theoretically to the president's oath. I'm sorry, go ahead.
Let me find it here. Where is it? Wait, hold on. Let me find the oath.
Support and defend.
Where's it? Here we go. So this is, that's the presidential oath. Here's the other oath. Article 6 of the Constitution. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. Now, Joe, what does that sound like? What list was that? Sounds like the exact list that they put in the 14th Amendment, right?
Touche.
It's
literally word for word. It's the list. It's almost like the drafters of the 14th Amendment were stealing from the founders.
Yeah, they're looking right at it.
So they're lifting the language. They basically went Claudine Gay and like plagiarized the founders.
Right. So they have it in there. And the best part is they say, and all executive and judicial officers. Now, interestingly, the president has a different oath. His is in Article 2. Right. And it does not say support. It says, let's go. Let me get back up to Article 2. Here's his oath or affirmation. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will to the best of my ability preserve, protect, and defend the Constitution of the United States. It does not say support. And I would argue that preserving, protecting, and defending is distinctly different from supporting.
How? Make your argument.
Which one of those is a synonym of support?
You can say that they're all manifestations of support.
No, I disagree with that.
Why
Preserving
not?
isn't supporting.
Preserving is stronger than supporting.
Is it?
Are you trying to make the philosophical argument here that his oath is a lesser oath than that taken by a senator or a member of the House?
No, but I'm just asking if preserving itself is stronger than supporting. I'm not sure. I think they're
what I'm
different
saying
things.
is if it's a stronger oath that he's making, and the purpose is you've broken your oath, and I think anyone would look at that oath as being that's even stronger. Support means I'm going to help it out.
Overall, I agree with you.
If your duty you're accepting upon yourself is that you're going to be preserving. I'm the last line of defense. I'm the last man I'm the captain on the boat, and the last man to leave the ship here, and I'm defending it. I'm preserving it. I'm defending it. You're not just supporting it. It's like you are the one who, it's like the Constitution basically lives and dies with you. That's more than supporting it. You're living and breathing the Constitution. That's essentially what you're saying. So if the nature of the wrong that is being breached is that how dare you make an oath to support, and now you're going to insurrect against that which you made an oath to support. Now we take someone who makes a much bigger oath and they in theory insurrect. That's an even greater offense. So that's why I'm like, if anything, I think it's safe to say that this is a more significant oath that the president is taking, and rightfully so. It makes sense that he should be making the biggest oath anyone makes with respect to the Constitution. So all the more so, the offense of insurrecting against the Constitution, insurrecting against the United States, would be that much a bigger breach, and he should qualify there. So that's why this whole oath.
I disagree.
Okay, go for it.
Here's why I disagree. Because congressman's role is to support the Constitution, right? So they violate the oath. They violated their duty to support by insurrecting or rebelling.
Okay.
The president, I agree, it's a bigger infraction. However, the roles are different. Congress's role is to support it. The president's role is this bigger thing, which means that the president's ability, which as we've already determined is less clearly defined, his ability and his responsibility, and therefore his actions are distinctly different. If he is the manifest will of the country, to insurrect against the manifest will of the country as its representative is harder than in any other way, right? Because here's what you do. How does an officer of the executive insurrect against the president as the representative of the country's will? He just doesn't do what he says, right? He takes up arm or rebels against him. But how does a president rebel against himself? How can a president rebel against himself? Like,
this is not an oath argument you're making, and it's impossible for him to insurrect argument. That's
because of his role in his oath.
You see, but that's a different argument. That's not an argument that the language in his oath that the language in the oath that's written in section 3 here doesn't apply to him. You're basically saying it's impossible for him. It's just philosophically impossible for him to insurrect, which we already pointed out that's not true, because on January 20th, if he was to come in there at 11:50 p.m. and start shooting up the elected president, I think we all would agree that that's an insurrection. Even though he's technically the president.
Would you agree with that?
I would totally.
What if there was conclusive proof that the election was stolen?
It might be a justified insurrection.
It's not an insurrection.
It might be a justified.
The other one would be the insurrection.
The Constitution has certain provisions in it. You're insurrecting against the Constitution. Constitution says this is how steps are going to happen. And if you say that, damn the Constitution, I'm going to do things the way justice demands, you are insurrecting the Constitution. Now, maybe you're saying in that instance the Constitution is wrong, but you cannot say you're not insurrecting. You're not insurrecting against the laws of this nation, because the proper procedures are followed. So,
but the proper procedure for the president is to deploy the National Guard to suppress insurrection, isn't it? Deploy the militia. That's his role as commander in chief, is to deploy the militia to suppress insurrection, specifically listed in Article 2. In fact, I'm pretty sure that's the only place in the Constitution, other than the 14th Amendment, where insurrection is
let's
mentioned.
time out for a second. I want to try and divorce from this particular incident and say, let's imagine this got blown up more. Let's pretend it's the end of his second term. Okay, it's the end of his second term, and he's like, I'm not leaving. I'm staying here. So now forget about him losing the election and whatever. You're trying to give me well, maybe he has justification for it. And so therefore it's impossible for him to insurrect. And I'm trying to shoot down, excuse me, and give an example where it's possible for a president to insurrect. And my point is, it's 11:50 p.m. at the end of your second term, and you're basically saying, I'm not leaving. And now you're telling me that, and I'm start shooting up the entire place where the new guy is being sworn in. Tell me how that's not insurrecting.
How? It depends on the reasoning, though, right?
His reasoning. What do you mean? No.
If his reasoning is I'm just staying, then yes, it's insurrecting.
It doesn't depend on. Once you say it depends on his reasoning, you're already admitting that I'm correct. That if his reasoning is not appropriate reasoning, then it would be an insurrection, which means it is possible for a president to insurrect.
Yes, I didn't say it was impossible. I said it's conceptually difficult for a president to insurrect against himself. And if you remember the beginning of our conversation, I said, because this is right where we got cut off.
Yeah.
I was saying that if I commit a crime on January 5th, but I'm charged on January 25th, I'm not charged with the crime effectively January 25th. I'm charged with the crime on January 5th, right? So if the president is impeached, because we were asking if a president can be impeached when leaving office.
After he leaves office.
Yeah. And I say, I think he can. I mean, the Supreme Court hasn't answered that question, but I think he can because he's impeached as of the time the acts and occurrences have happened. Now, it may not matter in some respect, right? Unless they determine that there's criminal immunity that has to follow an impeachment removal proceeding.
Right.
So we don't have the answers.
Which is the whole presidential pardon thing that's coming up next week on January 9th.
Right.
Right. I mean, January 9th, that's the DC Circuit Court is going to be arguing about whether or not there's presidential immunity because of the fact, and one of the two bases raised was because of the fact that there was no conviction at the Senate, and that the impeachment clause dictates that you cannot be held criminally liable unless you're convicted by Senate on your impeachment hearing first. So, right.
And I think
which, by the way, I don't know about you, but I certainly plan on live streaming that the oral argument's supposed to be January 9th, and I do plan on live streaming that. So.
I'll have to see what I'm up to.
But early in the morning for you, it's 9:30.
I'm actually
8:30 your time.
I'm up very early these days, usually going back to bed at that point in time because
that's I just wanted to share with the audience that I will also be. Whether you are or not.
I don't know if I will be. Unlikely, because I'm generally pretty busy. If I am awake, I'm still usually busy. That's why I'm awake. But I want to say we'll eventually find out what the Supreme Court says about that. Hopefully, I do think that it will be limited. Any criminal immunity would be limited to acts as president. I certainly think there are ways that a president could insurrect. And in your 11th hour.
So once you can insurrect, now let's bring this back. Okay. Forget about once you can insurrect. So now what about your whole argument that his oath means there's no such thing as him insurrecting?
I didn't say no such thing. I said
that his will is the nation's will.
It is, as long as his acts are as president and he maintains a political will. But Joe, there's
no, that's not true. He has to act consistently with the Constitution.
And there's a political answer for it defined in the Constitution, right?
What do you mean?
Impeachment. There is a way to determine that the president is not acting with the Constitution consistently, and that is to impeach him. Am I not correct?
Yes, you are.
By what other mechanism do we determine that a president has acted inappropriately?
No, that's the impeachment clause.
That's what I'm saying. And that's what I said right at the beginning, is that in my opinion, an impeachment must happen for a president to insurrect against his own country, because
it can happen anytime afterwards.
I don't know. Theoretically,
we can impeach Obama today.
Theoretically, right? we should be able to, if
I'll
we
tell you
wanted
this
to then
much.
ways beyond the statute of limitations on any insurrection, I would think.
There's a statute of limitations on impeachment? Doesn't nowhere does it say
Not
this
on impeach. I said on insurrection. So the question is, what would be the purpose of impeaching him? Would only
so that he
be
couldn't hold office.
right.
So you can't become a senator.
Oh yeah, I guess he could try and be a senator again.
Yeah.
Then yes, sure.
And
Impeach him forever.
I'll tell you something. You know, all the claims against currently going on against Joe Biden for the stuff that he did with when he was vice president. If they were to bring articles of impeachment against him, they wouldn't be impeaching him for his acts as president. It would be an impeachment for his acts as vice president. That he basically made an oath, and frankly, I think his offense is arguably the worst offense that any politician has ever done. I am so whenever I think about what he did, where even if he didn't take a penny, which I'm positive, I'm fairly certain based on the evidence we've seen so far, he's taken a lot more than a penny. But even if he never took a penny, for him to go out there and help his son sell the idea to the most evil, disgusting, corrupt businessman on the planet that DC can be bought, that it can be influenced, that if you give money to my son, that's going to change what happens in DC. For him to help sell that idea, whether it's phone calls, whether it's dinner meetings with these people, anything that he's doing, which he certainly knew at the very least he was helping sell that idea. That's why he's meeting with them. That is the biggest offense possible. It's the biggest stain, most humiliating thing in the world, because he's basically saying that this DC is for sale to the right buyer. And to me, that is the most egregious possible offense, because you're basically telling the world we are no less corrupt than anyone else. We are these gross, that our whole thing's about capitalism, truth, justice. That's all garbage. Just pay us, pay the right politician money vicariously through his son, and you can buy Washington, is gross and disgusting. I think that he's such an abomination as a person and as a politician, and everything about him is gross and disgusting. And people look at him like, oh, he's a doddering old man. Let's forgive him this trespass. To hell with that. Now I'm still not crazy about the idea of going forward. Even though I'm saying that, I'm still not crazy about the idea of going forward with impeachment, only because I know that they'll never be convicted by the Senate. They can basically show video of him taking from bags of money from someone, and Democrats will be like, there's no proof, which is why I think that's all political machinations. But as far as what should happen to this person, I'm certainly not urging any. Politically, what should happen to him is that he should be tarred and feathered in the worst ways possible, and held up there with literally Benedict Arnold. Like that, it should be Benedict Arnold and Biden should be mentioned in the same breath. Every time you talk about the biggest traitors to America, it's Benedict Arnold and Biden.
So I missed a little bit of that, but beautiful. I agree.
You're on playback.
My internet dropped for just a second again. But here's the thing. I agree, and I would say that the vice president can easily insurrect, as long as they're vice president.
Yeah,
and I
just go against president.
I don't think he would have any type of immunity from those acts as vice president. I don't think presidential immunity extends to the vice president, even under civil charges. So I think that's perfectly fine. I don't think Joe Biden would need to be impeached to be found in violation of Section 3 of the 14th Amendment. I don't know exactly what mechanism you would use for it. And maybe impeachment would be the proper way to remove him as president at this point. Or, an amendment or something, but effectively impeachment would be easier. But that is the quintessential problem, is that when they are president and have followed the process, they are president until the moment they leave office. And to get to your question about your 11th hour question, if the president determines that there is sufficient grounds to actually deploy military power to stop what he considers to be an insurrected election, then I think he can. Well, he certainly can do it. The question is, will he survive politically after that? Will the army listen and enact his will? Will he survive Congress's next move? Will he be voted back into office? What will be the follow-up to that? And that's really gonna require the political will of the nation. And that's why I think the president is so excluded from all of this, is because he is the manifest will. And as weird as this sounds, the president wins so long as he has enough of the population with him, no matter what anybody says.
Well, that's pragmatically. We're talking, there's a difference between legally and pragmatically.
I think it ends up being legally up until his term limit. Now, if he exceeds his term, presidents have exceeded their term by executing political power on the election. That has happened in the past, right?
Mm-hmm.
There was the guy who said, well, we got to investigate the election fraud. We're going to do this. They sent it back to the states, and it took a while for the next president to be inaugurated. There's a process around it. It wasn't like, political violence in the way we're talking about. But there is this question: as long as a president has the political will to not be effectively just killed by the people for taking over as a dictator, they can usher in a dictator. They have FDR, Obama. Yeah. Like, they've done it a bunch.
He's in his third term now.
The question is, like, when they leave office, and this is the funniest thing: Trump is accused of insurrection, and insurrection by the nature of trying to maintain office, because they're running it. The reason that they say it this way, Joe, is they're running into the philosophical problem we're talking about. They can't say Trump is insurrecting his own administration, so they have to say Trump is preemptively insurrecting the next administration, and yet he didn't, because on Inauguration Day, power passed to Joe Biden peacefully without a peep from anybody, including Trump. Nobody moved to stop it. So what insurrection actually occurred? No one can define it. And the reason they can't define it is because the president should have the executive power to investigate suspected election fraud all the way to inauguration. But once the constitutional process is complete, inauguration is the only time a president becomes president. That's the time. Joe Biden has a future interest in being president from the time he is read in on January 6th or 7th, I guess, but he does not actually manifest that property right of being the chief executive until Inauguration Day.
What about this? Because they would say he's insurrecting against Congress, that Congress is looking to carry out their function, and he's insurrecting to stop them from carrying out their constitutionally dictated duties.
The question is, what action is the insurrection? I guess what Colorado is saying, the action was delivering the speech and directing through my.
Oh yeah, well I think that they're a million miles away from being able to establish that he incited insurrection, engaged in insurrection. I think it's asinine to actually say that he did it. But if he had marched on, imagine if he had actually gone up there
like marched in with the crowd and led them
an
in
AR-15.
Down the halls.
Yeah, if he was leading the charge with an AR-15 and basically saying we're Congress is out of session. So cool. I think that would have been based as hell.
This is the thing with me, like, I don't know what the legal answers are, but I want to find out. Like, that's cool. Like, that's awesome.
So as far as would that be, assuming it wasn't, whether he's justified or not, as far as his motivations being justified, which you and I can agree that what the Democrats did with the way that they stole the election was just gross and disturbing, and that itself, that he's stopping them from insurrecting, I can understand that.
Yeah.
But let's pretend for a moment, okay, that he had literally lost, and we all knew that he had lost by light years.
Mondale to Reagan.
Yeah, that he basically got Mondaled. Okay, let's assume that had happened, and then he led a charge up to Congress saying, no, this election was stolen from me, whatever, like genuinely the crazy that they think he is, as opposed to him being justified in his position. So now, would you not think that that's an insurrection against stopping Congress from doing what they're supposed to be doing?
The follow-up caveat to that is pretty simple, right? Congress immediately issues an impeachment.
Right.
Shortest impeachment trial in history. You just play the footage of him. Here we go. Got this beautiful gun, wonderful gun, terrific gun. We're going to storm the Capitol. It's a nice Capitol, not as nice as the White House. We're going to go in there. Their halls are broad halls, wide halls. We fan out, and we're going to take Congress. We're going to wring their little necks. And Nancy Pelosi swinging from the lamppost outside. Like, you can imagine, okay, shortest impeachment trial ever, then prosecute him for insurrection, treason against the United States. There's a million witnesses. Done. He's no longer acting as president. He forfeits his role as president by doing that. by acting well outside the purview of the political will of the country and the laws, and his role as the president. To me, this isn't a complex question,
Right.
because that is obviously something that is not what a president is to do.
Mm-hmm.
So Congress gets to impeach him and then determine that he was unfit for office and acting as a high crime or misdemeanor against the country. It's in the Constitution that they can do that.
And I actually think in that circumstance, he'd be impeached.
Like he'd be impeached while he was doing it.
Convicted. Yeah.
I think
the Senate, at a certain point, it's hard to imagine the circumstances where we'll have a Senate, these 66 senators to all agree on the same thing. But that's one circumstance that I think, you would basically have.
Now, the crazy question is, what if they did? What if they didn't impeach? What if they're like, no, this was actually the right thing? Because the fraud was so manifest. And even though he got Mondale'd, right? But the fraud is so manifest, obvious, open, and notorious that everybody agrees. And that there's a dedicated core contingent of opposing political party that raises the impeachment articles, and they pass, but then it goes to the Senate and they're like, no, we know this was all bogus. We know everything was bogus, and he was actually doing the right thing. We're going to keep him. And they've manifest the will of the country to do that. Then he's still president, right? He's not impeached.
Yeah, that's
because true. The founders found it so sacred that the will of, I'm going to say the states, actually, the will of the states in selecting the chief executive was so important and so impactful that they provided one way to get him out. There's only one. It's just impeachment. That's it. There's no other way to remove him from office. And so we've added one. It's the 25th Amendment, where due to infirmity. But look at the process to actually do that. Like it's almost bigger than impeachment. The president gets to challenge it the whole time. Literally, is he in a coma? We can remove him. That's the only way the president has trouble challenging a 25th Amendment removal. So you have this one way that the founders originally put in there. Why are we suggesting that there needs to be these other ways to remove or prevent a president from holding office?
Oh, I'm on board with you on that.
Yeah. I just think the president is such a sacred role, and this is just wrapping this back to where we got on the subject. I think his oath is reflective of the sacredness of that role and his broad authority to do so long as his authority is representing the manifest will of the electoral base. It used to be the states, now it is the people in most respects. That's my soapbox speech on the presidential oath and why support is vastly different from what the presidential oath is.
Yeah, but I think you lose on that whole oath argument once you recognize that he can insurrect. Because the oath argument to me is predicated upon a notion that it's impossible for him to insurrect, because his will is the will of the people. And I think that once we recognize it's possible for him to insurrect, it cannot be that they're synonymous.
You're not listening to what I say when I say it's possible for him to insurrect. It is impossible for him to insurrect as president because he would necessarily be impeached and stripped of the power at the time.
But the impeachment would happen afterwards.
But the impeachment would be effective at the time of the acts, Joe.
I don't think that's true.
Really?
Why would the impeachment be effective at the time of the acts? Why would that be?
Wait, so
that's clearly not true, because by that argument, if you're saying the impeachment is effective it retroactively goes back to the time of the acts. Mm-hmm. So if in theory Biden were impeached and convicted for what he did as vice president, that would mean that none of his acts as president actually had any sort of retroactively, that they have no meaning at all. That doesn't make sense. That doesn't make sense to me.
I don't know if that has to be the same thing.
Why not? You're saying it works retroactively, that from the moment he took those acts that were the cause of his impeachment, and now we've later deemed them to be impeachment, that he's impeached as of that moment. So in that case, I don't think it works retroactively like that, because that's what you would be saying in a case where anything any law, any EO that Obama wrote after he's impeached tomorrow, he's impeached next month and convicted, and now any law he wrote afterwards, we say, well, that law gets ripped up. That doesn't make sense to me.
Actually, I'm gonna disagree, and I'm gonna say yes, it does. It actually goes back retroactively. I'm gonna take the bold position right now, Joe. You know why?
Because you're insane.
No, because there's a vice president who can very simply verify or nullify the acts of the prior executive.
How would that happen after the fact? What does that mean? You're telling me impeachment can happen 50 years from now. We can impeach Obama, according to your argument. That it doesn't have to be while the person's in office. So we could impeach Obama 50 years from now, and then you're going to say retroactively anything he did from that date of impeachment onward would no longer be law. So other laws that he wrote after that impeachment, which a lot of people were dependent on that law for and figuring out how they should conduct themselves.
This is actually easy to answer. This is really easy to answer, Joe.
Go for it.
Because the subsequent executive has full authority because the executive office exists exists beyond the president. The president is the executive power is vesting in the president while he's in office, right?
Okay.
But the executive power isn't newly created with the next president. It's the same executive power, which is why presidents have the ability to immediately nullify by executive order any prior executive order, right?
Yep.
So shouldn't it stand to reason that the subsequent executive gets to make the determination about what acts which are nullified get to stay and which get to go? And when you say, okay, well, what if he decides they do all go? We actually have a process by which the courts can determine you cannot repeal an executive act so simply, right?
Because he cannot repeal it retroactively. In other words, Biden, with Trump, when he wrote a bunch of EOs that on January 20th, Biden ripped them up one by one before he laid his head on the pillow. He's like, hey, that America First Act that's stopping the drug companies from jacking up prices and forcing them to charge the lowest price that they charge any country, that's what you have to charge Americans, and basically was a salvation for black people who have diabetes. I'm ripping that up because it has Trump's name on it. Now, does that rip it up retroactively? No, it rips up as of January 20th. That it's no longer in effect. You're saying now that this would work retroactively, though, and I'm saying that's pragmatically impossible to function. And I don't care if he's got a vice president. His having a vice president is no different from him having a secretary under his desk who's that's not doing anything. It's not doing anything politically, or it's not doing anything legally. The fact that he has a vice president isn't changing anything. And that's what I'm saying. The only power they have is going forward, not retroactively.
I disagree.
When it comes to impeachment.
I disagree because the subsequent executive gets to either validate what was done or attempt to allow it to expire retroactively. But courts have oftentimes prevented the repeal of an executive order by a subsequent executive when it is sufficiently burdensome on the people who have used the order.
Can you give me one example of an EO that was retroactively decimated?
I can't, and here's why. Because if they attempted to retroactively decimate an order by an act of the subsequent executive, which is different than what we're talking about, but if they'd attempted, the court wouldn't allow a retroactively to happen because of the impact, exactly what you're saying, right? I'm saying that I agree with you, but there is a mechanism to preserve executive orders that would be unduly burdensome to retroactively repeal.
But you're saying it never took effect in the first place. If it happened after the date of the impeaching offense, in that case, it never took effect. So it's not a law. And decades later, we'd be like, well, that was never a law. Now, to me, I'm sorry. I can go along a lot with a lot of the madcap hijinks that you bring to this show, but this is one I can't.
It basically just goes to a question of equity, Joe.
And a question of equity would be like, hey, everyone's been acting with the assumption that this is the law, so hence. But let me ask.
You're with me. You're 100% with me. That's what the court has done. It's literally, and I'm telling you that there is a mechanism for this to happen, to preserve those executive orders that are necessary to preserve.
Yeah.
Why is this confusing?
No, I understand what you're saying. But now it's basically a law that essentially never existed, that we're going to pretend existed, and in theory pretend exists going. So
we do this
if we're just pretending it existed for the sake of pretending it existed. In that case, what is the actual? Then what's the nature and purpose of saying let's go back in time and apply this retroactively?
We actually do this, Joe. When a law that someone has been prosecuted under and convicted under is found unconstitutional, what happens? Does that person have an opportunity to have their conviction overturned? because the law was unconstitutional. Even though they were convicted under it, the law is subsequently found unconstitutional. Now what happens? Is the law retroactively repealed, allowing them to have their freedom? I mean, you can't give them back the time.
Right. But they would get their freedom, even though at the time that, okay, so you're basically saying it appeared like a law at the time, but it's no longer a law retroactively.
Right. Now, we can't burden people who have benefited from the thing. We can't expect everybody, oh, well, we got to give back whatever we got. Like, that can't be done. But if something is repealed effective at the prior date, then it was never a law in the first place. What if it's a treaty that bound us to some sort of thing, right? Like, what if it was an executive action that wasn't an order, but an executive agreement with a foreign nation that we found out was made, and it was it was a subversive one that happened because the president was treasonous in theory. And so I say it goes back. And then that we can no longer be bound by that executive agreement. How could we be if he wasn't acting as the executive? I don't think this is as problematic as you make it out to be, mainly because we have methods for dealing with this concept. We've just never had to deal with it in the drastic way that your reductio ad absurdum argument is that we impeach Biden or we impeach Obama 50 years from now when he's rotting in hell.
Yeah.
In the cold hell of Michael Obama's loins. Richard W. says Senate has to ratify treaties. Yes, but not executive agreements, which have the exact same force of law as a treaty. It's fun. It's a nice little workaround. They're just not as politically popular. But anyway, no. So
I need to think about your whole unconstitutional argument. To me, that's an interesting point that you're making.
Yeah, of course.
Is retroactively going back.
I think I'm just throwing knives at walls here, but I'm
let me tell you something. There was so much hash just being thrown there that I was just like, yeah, okay, I'm not none of this is affecting me. But that argument is an interesting argument. What about a law later deemed unconstitutional? Retroactively, we would say that even though you committed it while the law is in effect, it still would be something that we would say it was never a valid law. Hence, you would be set free. That's true.
Now we're getting way off into the
weeds. We're really gone into the weeds on this one a little bit.
I'm just saying who knows, right? Who knows? Like this hasn't come up. This hasn't come up in 150 years. The idea that we would impeach a president decades after they're out of office for some act and then have to figure out what the hell happens with everything else. And remember, my entire premise is that they're being impeached specifically for insurrection, which would just allow them to be charged with insurrection, since a president can't conceptually be insurrecting against himself. But now I'm saying that the acts constituted his stripping of the presidency effective at the time he did them, allowing for a subsequent charge and conviction. Like, this very, very hyper specific stuff. And we've never seen it. We've never seen anything like it. The closest we had was Trump, and they failed. They failed the impeachment, which poses an interesting question. I laughed at their double jeopardy argument when they made it, but then I thought about it. I was like, wait a minute. It's not double jeopardy. It's a conceptual double jeopardy, because if they failed to impeach him for the insurrection, how can they subsequently try him before a jury for insurrection? Because they would have to consider that he had the power to do what he did and was justified in the act by being found not guilty. Right?
Yeah.
And that's kind of what the impeachment clause states, is that after impeachment, subsequent to a conviction and removal, a president can be charged. Now, they want to read it that specific way. I'm not saying the court will, but when I first read their argument, I was like, well, this is dumb. That's not double jeopardy. This is a completely different matter than a criminal conviction. I was like, but wait, no. It's conceptually a double jeopardy, because the concept is a president is being retried for an offense he's already beaten for an act as president, and that he was justified in the act. How can he be criminally liable for something he was justified in doing as a chief executive? That doesn't make any sense. And so the argument actually is kind of sensical. I don't know if the court agrees.
I think there are stronger bases, but I mean, I think that the incitement, the argument that incitement is not engagement. I think the argument that this was I think the argument that it doesn't apply to the president is stronger. I think there's just a lot of
I do too. I just
a lot
don't
of
think.
stronger bases. I am curious about this though. I'm curious about can you envision a situation where petition for writ is not granted?
I can. I don't think. I think it's the longest shot. I think they have to. They have to do this.
I mean,
On,
right.
on Colorado specifically.
They can't possibly leave this hanging, right?
Right.
And can you envision a scenario where they find in favor of the Colorado court?
Again, like not logically. Logically, it poses so many problems. Now, what I can find, I can envision this. I can envision a Supreme Court taking the position that Colorado and effectively, I think they'll rope in Maine.
Yeah.
I think they can take the position that a state cannot find that a president is in violation of Section 3 of 14th Amendment.
That's what I think is most likely.
But they may subsequently find, I guess it's theoretically possible, they could find that Trump is in violation. Like they could say, a state can't, but we do.
I don't see that.
I don't see
that's not a question of fact presented before them. So I don't see how they would have the authority to do that.
Well,
I think the most likely thing is this. I think
it is a question of fact before them, right? Because there is a finding of fact and conclusion of law by clear and convincing evidence. I mean, they would have to agree with the Colorado District Court's finding of fact and conclusions of law. I think it's very, very unlikely. I think it's the most remote possibility. But in theory, they could create the structure that says if a competent court finds by a finding of fact and conclusion of law to a sufficient evidentiary standard that a president is in violation, they would say that the state court is not competent to do so, but they could adopt the state court's findings as the high court of the land, right? Like they can. I don't think they will.
I think it's very unlikely. I think they're going to dodge the whole insurrection question altogether.
Yeah, I think because
they don't want. There's so much political disfavor they can bring upon themselves for no upside and no benefit by them weighing in as to whether or not this was an insurrection. They know
I agree.
They'll get 100 million Americans furious with them if they say this was not an insurrection, and they'll get 100 million Americans furious with them if they say it is an insurrection. And if they could just knock out the entire legal issue by just saying states don't have the authority to make this call, and it can only be decided by Congress or the federal government. So right away, boom, these cases are done, and I think I think Chief Justice Roberts is likely to pressure KBJ, Elena Kagan, and Sotomayor to get at least one of them to sign on with them, so that, and for the purposes of unifying the country, so it's not turned into a whole political, the Republican appointed judges want to give Trump a shot at the ballot. So. Yeah. I think that's why I'm fairly confident that this is going to be a 7-2, at least 7-2 decision, and it really might be 9-0.
It should be. It should honestly be 9-0 that just says the 14th Amendment as written does not apply to a president.
Mm-hmm. Or if not done, even if it applies to a president, that it's up to Congress. That state that and if you understand that the whole agenda of this amendment was to strip states of power, to use this amendment to empower states to remove someone from the ballot, is just a 180 backward way of reading this amendment. And I think that argument is a pretty strong argument from an originalist perspective, a textualist perspective, and any perspective as far as understanding what the thinking of these people was when they wrote this amendment. I think that it's a really compelling argument that is likely they're going to use that. They're going to pressure Kagan or one of the others, to at least one of them, to sign on with them. But you're right, definitely should be 9-0, especially when you consider that the only way Colorado wins in keeping him off the ballot is if there's like 8 different legal questions that you have to say every one of these legal questions Trump loses on. If he wins on any single one of them, he's on the ballot. But he has to lose. He has to go 0 for 8. And for any of these justices to come out and say, yep, 0 for 8 on all of them, it can't apply to president, states can do it. It's the office holder he's an officer, and this wasn't an incitement, is a form of engagement, and this wasn't an incite. I mean, so many different things that if any one of them he wins on, and Colorado found that he was 0 for 8, I can't imagine that he's gonna that it's such a crazy perspective to think.
And
yeah, so that's why I think I'm confident it's gonna be it's gonna be at least 7-2 in putting it back on the ballot.
And I think it's likely unanimous, just because of the conceptual problems of allowing a state to do that are so hard to overcome.
Yeah.
So hard to like, okay, you determine that it applies to a president, I guess. I disagree, but okay. Now you're going to let a state do it. One state do that. My argument the other night is, what if the state is Florida and DeSantis uses political capital in Florida to keep Trump off the ballot in Florida? Now he can't win the Republican presidency. He can't without Florida.
Right.
Like, so wait a minute. We're gonna let Florida determine the Republican candidate by itself, or Texas, same thing. Like, what? How do we allow that? How is that in any way reasonable? And then the other question, the other issues I brought up earlier, which is, if a president wins subsequent to being found ineligible to hold office, is the state now in open rebellion? Because they can't recognize the chief executive's authority if he's not qualified. And then,
well, that's another reason to basically say that states don't have that power.
Right.
So,
yeah.
If they issue a termination, if they reach that termination, in that case, they're not open rebellion, because, you know, all of these findings are always like, you know, please, Supreme Court, weigh in here and let us know. Even like, it's like, we're making this decision, we're really positive about the decision, but yeah, whatever the Supreme Court says, you don't have to throw in that whatever the Supreme Court says, we're going to bend to that. That's automatic. The reason you throw that in is to basically say, we really don't freaking know what we're talking about, and we're hoping that the Supreme Court will tell us.
Yeah.
Otherwise, why would you write? It's up. We will bend to the Supreme Court. Oh, thank you for sharing that with us. We also breathe oxygen, and you
didn't have a choice, bro.
Yeah, like oh, that's nice of you. Why would you say it unless you're basically saying we don't know what we're doing. We have no idea what we're doing.
Yeah, I think that's the only way they can find it. Too many problems with doing it. And then as a final point, just reiterating that if a state can prevent a president from attaining office under the 14th Amendment, they logically must be able to prevent them from holding office, because that's what the amendment actually says. And if they can prevent the hold, that means that they would have some sort of removal power, which doesn't make any sense.
Yeah.
But yeah, man, that's why I think this is the most interesting legal shit to happen ever. Like, how are we here? Only because of one orange man, one Cheeto dusted individual who has so raised the ire and hackles of half the country, and so raised the spirits of the other, and the interest of anyone left between, that he has created the potential for so much Article 2 constitutional law that has never been asked by his hilarious antics. And then we have to yeah. I find it great. That's what I find it great. I understand it's really late, and you probably got to get out of here pretty soon.
Yeah, I need to get up tomorrow morning at some point. So it's 2:20 here. So yeah, but this is a fun. This is always a fun conversation. Like this topic. First, I mean, yeah, whatever. It's great seeing you on our anniversary, and it didn't
even get you anything.
Yeah, that's all right. You can get me a super chat or something. All right, my brother. Yeah, but this topic, we could talk about this for days. I haven't gone into the weeds the way we did with this crazy conversation about retroactive impeachments. That was pretty wild.
Where else are you gonna get idiocy? Right here.
That was fun.
Right here's the only place.
Yeah.
We needed Barnes on to make it really go nuts.
Yeah.
Could you imagine?
I'd love to get his feel on that, on that topic there. That would be really awesome to get his take on that.
Maybe we can organize a Barnes panel, because I'm curious. I know where he falls, like, in the grand scheme of things, but the way his brain works, and like, it's like, now listen, Joe, this actually happened 1869. It was this president, like, he'll just come up with some story. It's like, how do you know this? Like, this is obscure case in small town. He pulls
cases out of his ass. It's amazing. It's an amazing thing. Yeah.
One last thing before we go. Here's why I think presidential immunity has to attach prior to impeachment.
Okay.
I raised this to my homeschool class today. I teach. Never mind. at a homeschool co-op. I raised this to them. I said, imagine Trump comes to the big town near me, which is Wilmer. We're in a county of 50,000 people. And the county district attorney, 50,000 person town, decides that Trump's speech incites a riot or an insurrection. And he charges him under state law incitement claims. He kneecaps the president of the United States effectively by making him guilty of incitement to insurrection under state law in a 50,000 person county that may be hostile. Now, we're a red county generally, but hypothetically, if not, like put it in a blue county. How can we possibly allow a county district attorney in some state that may represent 50,000 people total to hamstring an entire presidency or the entire executive branch? They have to have immunity prior to impeachment. Just because we haven't had this happen, because you can't pardon themselves. Theoretically, if it was a federal prosecution, they could pardon themselves.
The state they can't.
Then we'd have a question, but they can't pardon themselves under state law.
That's a great question. That's a great question.
Yeah.
Good job, brother. Good job.
I'm wondering why I'm just a dummy. Like, why haven't they briefed any of their petitions? Brief this stuff. Like, just pose the ridiculous hypothetical because it'll happen. The Democrats are mad that Republicans keep bringing federal cases in one particular district in Texas because they know the judge and they know he's super based and ultra right wing. They're like, well, this can't happen at the federal level. It'd be way worse at the state level.
Yeah.
It would be. Anyway, that's my hypothetical for the day.
Love it. Love it,
brother. We got to talk again soon.
And to Nick's chat, I'm just going to say, stand back, stand by. Godspeed.
Peace, brother. Leave. There we go. He's gone. He's gone. I love Joe. So glad he was able to come on last minute. I was like, I really want to talk about this 14th Amendment stuff and get into it a little bit more because it's one of the few areas of law that I really like to look at. I mean, we can only guess because the Supreme Court has never answered these questions. We can say how they should answer it, but we don't know how they will answer it. And all of the things that we brought up, they may have other answers for. I mean, they have extremely deep diving law clerks, and they have tons of resources, and these are going to be fully briefed by very, very competent counsel on all sides of this, including amici briefs. So we've got tons of research that's going to go into this topic that will know way more, that will go way deeper than Joe and I are able to go just off the top of our heads. But the philosophical questions, the conceptual problems, and the fact that we're going to make law on a 150-year-old amendment that this question's never been asked from, and that one of the things we have to ask is, has it never been questioned? Because prior to this political environment, no one thought the 14th Amendment would apply to a president. Kind of like when they go, well, Trump is the first president to be indicted. We go, well, why is that? 235 years. Is it, yeah, I think it's like 235 years. They never bothered to indict a president. Was it because all the presidents are just sparkling bastions of law abidingness, or because they just didn't think they could and they thought it might be really risky to do so? So that's the question. Like, which one is it? How do we get there? And then we need everybody to come in, do all this research, make the arguments. Supreme Court will determine what the law is because of Marbury versus Madison, and then we're stuck with it. I find that fascinating. I don't know where it's going to go. I know where I would take it, but I'm just a dummy on the internet. And so for me, this topic manifests all of the things I like about law, the constitutional questions that are big, that are impactful, they'll change the future forever. And that once they set them, they will then become, a battleground hypothetically far off in the future. But how far? Is it going to be another 150 years, or will it be next term? We don't know. So that's why I wanted to talk more about this. What we are going to do right now is actually, we're not going to do anything. That's cool. Excellent. I thought I had to do an ad read today, but turns out that's next week. Excellent. We'll skip that. Buy Field of Greens, fieldofgreens.com. I love them. I was going to do the Field of Greens ad read. Turns out I'm not obligated to this week. And here's what I will say. I'm not obligated to do this read, but you should check out Field of Greens, fieldofgreens.com. Promo code knows. I'm a big fan of it. I like it. It's good stuff. It provides you some fruits and vegetables. I'm not going to do the full ad because I don't have to, but I'm just going to say you should get it because I think you should. Let's read the YouTube super chats. Sorry, I've been holding off on them. Lately, I've been going in them as we go, but with Joe, we were in a good conversation. Ryan, the editor, says, "Hey, girl, what's your ring size?" I don't even remember. It's less. I've lost weight and my fingers got thinner. Probably from the AIDS. Alias Unknown says, suffer, Ricada, in Ralph voice. Hey, thanks. Isaac Baruch's Wholesome Gabagool Art says, "Hey, Nick, I'm a hot 26-year-old electrician who loves Warhammer 40K, law, and degeneracy. My name is Randy. Can you please toast my big mommy goth milkers?" Hey, Randy, look, man, I don't know how you got those big mommy goth milkers. Maybe Randy. It's not Randy with an I, it's with a Y. So I'm thinking you're a dude, but I'm proud of you for undertaking that top surgery. Inflate those big boys. Drop that goth hair. Get that ultra white foundation and concealer, and you go get it, big boy. Cheers to you. Ed2276 says, "The Constitution doesn't grant Congress power over immigration. It says naturalization, how one becomes a citizen. Why don't states have power over how foreigners enter the state without naturalization?" Actually, that is probably because the president is the sole organ of foreign relations. And that is how, if you pay attention to the news stories about the Texas thing, it's being framed. You're finding out Mexico's mad about it, blah, 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 blah. It's being framed as a foreign relations issue, that the border is a foreign relations question and the president is dealing with it in that respect. It's not necessarily true. That's just how it's being framed. And you have to say that if that's the question, the president's going to win. The president wins that question every time, unless they say that border enforcement is not a foreign relations issue, which is a tough claim because it is the border with the foreign nation. So we'll see, though. I've made the argument for why Texas should have the power to do that. I don't know what the answer is ultimately going to be, but if the government just shirks its responsibility of faithfully executing the law to protect the border that they're commanded to protect, can a state protect their border? Maybe. Well, who knows? Cheesy Tarian says, "Joe, if it was just the camera was frozen, we would still hear Nick." Oh yeah, no, my internet dropped completely. He also says, "In the union is greater than state putting a person on a ballot." Yeah, that's the Colorado and Maine position. It's amazing. The Green Skull says, "What kind of American are you, Joe? A Daily Wire and InfoWars?" I don't think he's either of those. Isaac Brooks, Wholesome Gabagool Art says, "Only Nick could look at Stephen Hawking as an inspiration right after the crippled man was on Epstein's flight logs. Hope the lawsuit's going well." I've never looked at Stephen Hawking as correction. I looked at Stephen Hawking as an inspiration a long time ago when I was like, oh, this guy's a great theoretical physicist, and didn't know anything really about him. Once I started learning about him, and this has been for well over a decade, I thought he was a piece of shit, complete dirtbag, and I have very little respect for him. I said he's a good mathematician and physicist. That's literally where it ends. I mean, people can be skilled at something, but I've been very critical of Stephen Hawking for way lesser infractions than that one. Charlie Waters says, "You're making this too complicated. Whichever side the president takes in an insurrection is the side of America. Lincoln could have sided with the South." Yeah, that's kind of what I was saying. In some ways. Killer Potato says, "Why haven't people who have been done for weed been let free then? Because it's been made not illegal in certain states." Weed is still federally illegal, although it possibly will get rescheduled. It hasn't been found unconstitutional. Now, some states like Minnesota has legalized marijuana and has created a program to review the possession convictions. I think there's like 70,000 possession convictions in Minnesota, and look at vacating those convictions and pardoning the people who were convicted. But there's a process to that. It was not found unconstitutional, so there's not this idea that it can be rolled back in that way. The Under Armour Gamer says, "Can someone who has been pardoned become a vice president? Just asking because I'm curious. Someone, you don't have to be pardoned to become vice president or president. There is no restriction on becoming president that has anything to do with criminality. In theory, you could be a capital murderer on death row and become president of the United States. In theory, you can. I don't know how practically you would manage that feat, but if you could, that'd be awesome. But yeah, there's no restriction on attaining the office of the president or holding the office of the president as someone convicted of any level of crime from misdemeanor to felony. They would have to impeach them. In fact, the same with federal judges. One of the Nixon cases, not President Nixon, but Judge Nixon. The judge was found guilty of bribery, but he was a federal judge with a lifetime appointment. To remove him from the bench, they did end up having to impeach him because he's still a judge and he was still entitled to the federal judge's salary and benefits, even though he was in prison. So they had to impeach him to remove him as a judge. So that isn't a burden that can disqualify someone. So there you go. Typically, they just wouldn't be elected, right? But that is how it happens. Okay, YouTube. We are done. We went really long on YouTube tonight, but we were having a great conversation. Oh shit, Cheesy Tarian also says Nick was swatted by the sniper from Ruby Ridge. That's true. We are done on YouTube. We're going to flip over to Rumble. We'll keep the show going for a little while here. We've got more to talk about. We'll probably get into this Epstein list a little bit. I don't know. There's so many places that are like talking about the names. We'll figure out how to do it. I'm still torn on exactly how to cover it. Bill Clinton's on there. Obviously, it's pretty funny. Well, depends what your definition of child is. We'll keep talking about that. And I do have some other topics that we may jump into. Follow the link in the pin chat or in the description to pop over to Rumble. Otherwise, we'll see you not tomorrow. I will not be streaming tomorrow night. We'll see you Monday, I believe. Until next time, guys. Peace. Peace. See you on Rumble.